Now we go on to understand the various theories which exist with respect to the law of tort. These two theories are whether it is a law of tort or whether it is law of torts. Now, why is this differentiation important? We will see in the foregoing slides. Now, what is the law of tort? It says every wrongful act for which there is no justification or excuse has to be treated as a tort. So every act which results in a legal injury or which results in an injury should be treated as a tort. However, the law of tort says that there are only specific number of wrongs and beyond which liability under the branch of law cannot arise. So law of tort says that every wrongful act which has no justification or excuse should be a tort, and hence tort, because it is an ever expanding field. There is no limitation in this. However, the law of torts says that there are only limited number of wrongs which are there. And if one of those wrongs is committed, then you are liable under law of torts. Otherwise, there arises no liability. Now, this law of tort theory was propounded by Winfield. And according to Winfield, every wrongful act for which there is no justification should be treated as a tort. So, for example, according to this theory, if I injure my neighbor, he can sue me in tort whether the wrong happens to have a particular name like assault, battery, deceit, slander, etc., or whether it has no special title at all. I will be liable if I cannot prove lawful justification. So, for example, it says there may be some wrong which has happened which has not been put into a category of a particular wrong yet. For example, it has not been put under the wrong of assault or battery. Yet, if there is an act which is without justification or excuse, it has to be treated as a tort. The Latin maxim which favors this is ubi jus, ibi remedium. Wherever there is a right, there is a remedy. And it was propounded that if a man will multiply injuries, the action also must be multiple. For every man who is injured ought to have been recompensated. So every wrong which is done should be compensated. So ubi jus ibi remedium means wherever there is a right, there is a remedy. However, as opposed to this, now what this theory actually propounds is whenever there is any wrong without a justification done, you will be liable for a tort. However, as opposed to this, Salmon prefers the alternate, and it says there is no law of tort but a law of torts. Now, what do you understand by law of torts? He says the liability under this branch arises only when the wrong is covered by or one or other nominated torts. So, there is no general principle of liability. And if the plaintiff can say that this is one wrong under which the action of the respondent can be placed, then only he will be successful. So it is called a pigeonhole theory. There are specific pigeonholes under which you have to prove that one wrong has been done. If there is no pigeonhole under which the plaintiff's case cannot fit in, the defendant has not committed a wrong. So law of torts says that there are specific grounds on which you can take remedies. You cannot take remedies for any wrong which has happened. Now, what is the current status? The law of torts is an expanding field, not restricted, but yet it is not a field where every wrong is compensated. So it is a mix of both. It is generally law of torts where you have to prove that this and this wrong is done. But if the court develops a new wrong, another pigeonhole is added. For example, India has developed the concept of absolute liability, whereas globally the standard is strict liability. So we have created another pigeonhole. See, law is something which is dynamic and not stationary. There will be wrongs which will keep happening and you will have to amend laws with respect to that. So this means that if there is a wrong which has happened, if there is a new pigeonhole created, then you can have a liability. There is no general principle of liability as such till today. Now, according to Salmon, just as the criminal law consists of a body of rules establishing specific offenses, so the law of torts consists of a body of rules establishing specific injuries. You have specific injuries for which you can claim. Neither in the one case nor in the other, there is any general principle of liability. Whether I am prosecuted for an alleged offense or sued for an alleged tort, it is for my adversary to prove that the case falls within a specific and established rule of liability, and not for me to defend myself by proving that it is within one specific and established rule of justification or excuse. What does this last line mean? It says whether there is a wrong done by me is for the plaintiff to prove. The plaintiff proves that this and this wrong is done by me, and when this and this wrong is done by me, I will be liable. And it is not on me to prove, no, I have not done any wrong. It is not my fault. And that I have so and so justification or excuse for doing it. So there is a pigeonhole. You prove that first I fit into the pigeonhole. Taking a defense or exception is the second stage which comes in, right? So Winfield says law of tort and Salmon says law of tort. We go on to the next two essentials, which are very important to understand the concept of law of torts. To constitute a tort, it is essential that the following two conditions are specified. So there are two conditions which must be specified for any act to be considered to be a tort. There must be some act or omission on part of the defendant. So either there has to be an act is a positive thing, or an omission that you've forgotten to do anything, or you've intentionally not done anything. So there is an act, a positive step, or an omission, not doing something. The act or omission should result in a legal damage. A legal damage. There has to be a wrong legally done, not a moral damage, a legal damage. That is injuria. It's called injuria. That is the violation of a legal right vested in the plaintiff. So it is a violation of a legal right which is vested in the plaintiff. Okay, so the plaintiff here has to prove that this is my legal right which has been infringed, and then the remedy of torts will be available for you. So first, let's understand what does an act or omission constitute. Now, in order to make a person liable for a tort, he must have done some act which he was not expected to do, or must have omitted to do something which he was supposed to do. I am not supposed to hit somebody, but I did that act. I'm supposed to not cause nuisance or not cause negligence while dealing with something, and I do that. So I do something which I am not supposed to do, or I omit to do something which I am supposed to do. So there has to be a positive or a negative act. Either a positive wrongful act or an omission which is illegally made will make a person liable. So something that is not lawful, that is wrongful, will constitute a tort. The wrongful act or omission must be one recognized by law. And if there is a mere moral responsibility or social wrong, there cannot be a liability for the same. So for example, if I'm standing on the beach and if I see somebody drowning, it is a social or moral obligation on me to save that person because there are 10,000 other people also standing on the beach. However, if I am a lifeguard whose job is to protect that person, that is a legal responsibility on me because of my job. Then I will have to protect a drowning person. But a mere standby person is not obligated to protect. Similarly, it is my moral duty to feed somebody who is hungry, or it is my moral duty to tell somebody that there's a hole, please be careful. But it is my legal duty not to dig holes unnecessarily to cause nuisance or to injure people. If there is a hole and if I have not done it, I am not obligated to tell somebody. Moral responsibilities and moral duties are not covered under acts or omissions. It is only those duties which are enforced by law which are covered under this category. Now, next is there has to be a legal damage. Not every damage is remedied. It has to be a legal damage. Okay, so in order to be successful in an action for tort, the plaintiff has to prove that there has been a legal damage caused to him. In other words, it has got to be proved that there was a wrongful act, an act or omission causing the breach of a legal duty or a violation of a legal right vested in the plaintiff. There has to be a legal damage. A moral damage does not count here. Correct? I'm not supposed to pull a chair if somebody is sitting. If I do that, I cause injury, I am liable. But if I do not know that the chair is broken and if somebody sits on it and I am a bystander, I will not be liable for a wrong which has happened. If there has been a violation of a legal right, the same is actionable, whether as a consequence thereof, the plaintiff has suffered any loss or not. Now, for example, I have suffered a wrong, but there has been no damage which has happened to me. Yet I will be liable to be compensated. If you trespass my land, do not injure anything. But if I catch you trespassing my land, you are liable for the wrong. I may not have suffered any loss, but you may have done it. This is expressed by the maxim, injuria sine damnum. Injuria means infringement of a right conferred by law on the plaintiff or an unauthorized interference, howsoever trivial, with the plaintiff's right. What is important in law and in the law of torts is injuria, injury. Injury means the injury, the wrong done to the legal right of a person, an infringement to the legal right. Damage, damno, which means damage, is not relevant in the law of torts. It may be a very trivial damage which happens. You may have, somebody might have trespassed your land and broken a plant. Very trivial damage. Might be some random shrub also. That amount of damage in terms of the money compensation involved here is not important. The fact that you have a legal right that nobody trespasses on your land is something which is very essential. And that should not be damaged, right? So injuria is important. Injuria without any damage, then also you have a remedy under law of torts. It may be very trivial, but it is permissible. Damnum means substantial harm, loss, or damage in respect of money, comfort, health, or the like. Now, nuisance, I have a right that you do not put garbage outside my house. It might cause a little discomfort to me in terms of smell or in terms of aesthetic value, but it may not do a lot of damage to me. Yet you are violating my right of living peacefully and causing wrongful interference of my use and property. You will be liable. Always remember, in law of torts, injuria is important, damage is not important. Thus, where there has been an injuria or a violation of a legal right, and the same has not been coupled with a damage or harm to the plaintiff can still go to the court of law because no violation of legal right should go unaddressed. The law is that if there is a violation of a legal right, the law says that if a legal right is violated, then you have a remedy. Correct? And that remedy will be by the court of laws. When there is no violation of a legal right, no action can lie in a court of law, even though the defendant's act has caused some loss or harm or damage to the plaintiff. Now, I have no legal right infringed if my competitor opens a shop next to me. There will be monetary losses which have happened to me. If I have a shop, for example, I have a grocery store and I am the only grocery store in the entire locality and my neighbor opens a grocery store next to me. I will have what kind of damages? Monetary damages. But is there any legal right violated? Do I have the exclusive right to open a grocery store in my area? No. In this case, I cannot go to the court and say, tell him to stop the business. Why is he doing this business? That is not allowed. This is expressed by the maxim, damnum sine injuria, damage without injury. Damnum means loss, harm in terms of money, comfort, health, and injuria means violation of a legal right. So this is damnum sine injuria. A damage without a legal injury, not actionable in the court of law. It means that a damage without a violation of a legal right is not actionable in the court of law. The reason for the same is that if the interference in the right of another person is not unlawful or unauthorized, but as a consequence of his exercise of own lawful rights by the defendant, no action should lie. Because otherwise the law of torts will become a problem for people. If I start doing something and if it injures me financially, I will go to the court for remedy. Unless my legal right is violated, there is no remedy which lies. Everybody is free to exercise their own lawful rights. Thus, the test to know whether the defendant should or should not be liable is not whether the plaintiff has suffered any loss or not, but the real test is whether any lawful right vested in the plaintiff has been violated or not. So the test is not monetary damages, but legal damages. A legal injury is the test and monetary damages not the test. Now, injuria sine damno, injury without damage. This means violation of a legal right without causing any harm. Now, there are two kinds of torts. First, which are actionable per se without proof of any damages or loss. Assault, battery, these are actionable per se. Second is that you have to prove some loss has happened to it. We will cover these categories when we subsequently understand the entire law of torts, but these are two categories. Now, injury without damage covers the first case. In such case, there is no need to prove that a consequence of the act, a harm has been suffered. You have suffered any harm, it's not required to be proved. Harm in terms of damage. If you prove there's a violation of legal right, you are free to go to the court. In case of injuria sine damno, the loss suffered by the plaintiff is not relevant for the purpose of action. It is only relevant as regards to the measure of damages. Means that the amount of loss is not relevant. It will only be relevant when you calculate the amount of money to be paid. Correct? If the injury results in no loss, the injury, that means the violation of legal right, you may be awarded some exemplary or nominal, minimal damages. If the plaintiff has suffered no harm and yet the wrongful act is actionable, the question which arises is how much compensation to be paid. And in this case, normally nominal damages are awarded, means minimum damages. Correct? Minimum damages, nominal damages. Now, Ashby versus White, this is a case wherever there is a right, there is a remedy. Injuria sine damno means wherever there is a right, there is a remedy. Ubi jus, ibi remedium. Just here means a legal right. So, ubi jus, ibi remedium is a case here. It says that the plaintiff was a qualified voter at a parliamentary election, but the defendant, the returning officer, wrongfully refused to take the plaintiff's vote. So if I did not vote, now no loss was suffered by such refusal because the candidate for whom he wanted to vote won the election in spite of that. So I wanted to vote for X, I was not allowed to vote for X, but X won. Is there any monetary loss which happened to me? There is no loss which happened. The candidate who I wanted to win has already won. It was held that the returning officer, who's the defendant, is liable. Why? There is a legal right vested in me to vote. I have a legal right to vote. If I am not allowed that right, I can hold the other person liable. Justice Holt said, if the plaintiff has a right, he must, of necessity, have a means to vindicate and maintain it, and a remedy if he is injured in the exercise of enjoyment of it. Indeed, it is a vain thing to imagine a right without a remedy, for want of right and want of remedy are reciprocal. So the court says that whenever there is a right, there is a remedy. The fact that I had a right and it was not allowed to be used by me is something which is actionable. Here there was no damage as such which was caused, but it is actionable. Bhim Singh versus State of Jammu and Kashmir is a case in the Indian context in similar circumstances. The petitioner was an MLA and he was wrongfully detained by the police. The police wrongfully detained him while he was going to attend the assembly session. He had the right to be present for the session because he was an MLA. He was not produced before the magistrate within the requisite period, and as a consequence, the member was deprived of the constitutional right to attend the assembly session. There was also a violation of fundamental right as to personal liberty guaranteed under Article 21. By the time the petition was decided, Bhim Singh had been released, but as a way of consequential relief, exemplary damages amounting to rupees 50,000 were awarded. And 1986, 50,000 rupees is an exemplary example. The court set an example that the person had a right and you have violated that right. So whenever a right of a person is violated, there is a remedy. So this is an example of two things: injuria sine damno, and second, ubijus ibi remedium. Now, damnum sine injuria, it means damage which is not coupled with an unauthorized interference with the plaintiff's lawful right. Causing a damage, however substantial to another person, is not actionable in law unless there is no violation of a legal right of the plaintiff. So until and unless a legal right of the plaintiff is violated, there will be no remedy. This is generally so when the exercise of a legal right by one results in a consequential harm to another. So whenever a legal right of one person, when used, results in a harm to another, there is no liability. The mere fact that a man is injured by another's act gives in itself no cause of action. If the act is deliberate, the party will injure have no claim in law, even if the injury is intentional, so long as the other party is exercising a legal right. Even if I deliberately open a store next to my friend to kill his competition, the person will not have a remedy, because this is a legal right of mine. Now, Gloucester Grammar School is an excellent example of this case. The defendant, a schoolmaster, set up a rival school to that of the plaintiff. Because of this competition and setting up of a new school, the plaintiff had to reduce their fees from 40 pence to 12 pence per scholar per quarter. What had happened? There was one school in one area. That school was restricted to that area, and there was no other school in that area. Now, the defendant here set up another school which resulted in a competition. Now, it was held that the plaintiff has no remedy for loss thus suffered by them. So, there was no remedy available with them. Damnum may be absque injuria. This means damage may be there without violation of a legal right. The court explained this with an example. If I have a mill and my neighbor builds another mill, whereby the profit of my mill is diminished, I have no right against him, although I am damaged in the sense of money. But if a miller disturbs the water going through that mill, or does any nuisance of like sort, I shall have an action as the law gives me. For example, that person obstructs the flow of water or electricity, or causes problem to your property that you are unable to use your mill. That will result in a problem. Otherwise, there is no problem, no remedy available. This is another case. Town Area Committee versus Prabhu Dayal. Now, in this case, the plaintiff constructed 16 shops on the old foundations of a building. Now, you constructed 16 shops, and this construction was without giving any notice for construction and without obtaining any approval or necessary sanctions. Before you construct, you need sanctions, you need governmental approval, you need to get the maps cleared, everything. Now, the defendants, that is, this went into appeal. However, the town area committee demolished this construction. Okay. Now, here there is a legal damage which is done to the person. Sorry, there is monetary damage done to the person. There is a monetary damage which has happened. And in an action against the defendants to claim compensation for demolition, the plaintiff alleged that the defendant was illegal as it was malified. Now, the plaintiff also claimed that this demolition was done with a malified intention, evil motive. However, the court again said it was held that the defendant was not liable as no injuria, that is, no legal right could be proved, because if a person constructs a building illegally, the demolition of such building by municipal authorities would not amount to causing injuria to the property owner. You did not have a legal right to build it. Had you gotten the maps cleared, authorities were informed, and then the building was made, and then some damage would have been done, then you had an injuria. Right now, you only have monetary damages. No legal right was infringed. Now, the next category of discussion moves on to what is the mental element in tortious liability. See, do you understand by mental element? The malice in fact, that is the evil motive or the evil intention to do a wrong. Like in the case of Prabhu Dayal, he claimed that they did it out of evil intention. There are some torts where evil intention is relevant, and in some torts it is not. Now, in some branches of law of torts like assault, battery, false imprisonment, deceit, malicious prosecution, conspiracy, the state of the mind of a person is relevant to ascertain his liability. That means fault when relevant, that means where is mental element relevant. There are certain areas where mental element is quite irrelevant and the liability arises even without any wrongful intention or negligence on the part of the defendant. In such cases, innocence of the defendant or honest mistake is no defense. If I keep injurious animals on my property, even if I keep them innocently or I do dangerous activities on my property, even without mental element or a state of mind, I will be liable. These are strict liabilities. However, in some cases, there is state of mind is relevant. Now, these are the terms used: a malice in law and malice in fact. A malice in law is a wrongful act done without a just cause or excuse. That is malice in fact law. And malice in fact is evil motive, ill motive, malice. I have jealousy against the other, or I want to injure, evil motive. So these are the difference. A malice in law is a wrongful act in law or without any just cause or excuse. And a malice in fact is an evil motive. Malice in law does not constitute an act done with an improper or evil motive. The motive, human motive, improper is not relevant. It says a wrongful act done intentionally without a just or cause or excuse. A wrongful act in the legal sense. Malice in the legal sense thus means malice such as may be assumed from the doing of a wrongful act intentionally, but without a just cause, for a want of reason or for a want of reasonable or probable cause. It is a wrongful act, may be done intentionally without a just cause. Malice in law simply means a wrongful intention which is presumed in case of unlawful acts. Malice in law in case of illegal activities is a presumption that you did it intentionally, you broke the law intentionally. It's a presumption rather than a bad motive. Bad motive is not presumed. Malice in fact or evil motive. In the popular sense, malice in fact or actual malice means evil motive of a wrongful act. So evil, why did you do the act? When the defendant does an act with the feeling of spite, vengeance or ill will, the act is said to be done maliciously. As a general rule, motive is not relevant to determine a person's liability in the law of torts. Generally, it is not. A wrongful act does not become legal if it is done with a good motive. Similarly, a lawful act does not become wrongful if it is done with a bad motive. Okay? Now, in the following exceptional cases, however, malice or evil motive become relevant in determining the liability in the law of torts. When the act is otherwise unlawful or wrongful, can be gathered from the circumstances. आप circumstances से समझ सकते हो कि कैसी वो act है. How does the act? In the torts of deceit, conspiracy, malicious prosecution, injurious falsehood, one of the essentials to be proved by the plaintiff is malice on the part of the defendant. These are essential elements. So where is it relevant? Where the tort itself requires it as an essential element. So in these elements, it will be done. In certain cases of defamation, when qualified privilege or fair comment is pleaded, a defense of motive becomes relevant. The defense of qualified privilege is available if publication was made in good faith. The presence of malice or evil motive negatives good faith, and the defendant cannot avoid liability by the defense of qualified privilege in such cases. So in cases of defamation also, if you claim qualified privilege, whether it was in good faith or bad faith, that is relevant. Causing of personal discomfort by unlawful motive may turn an otherwise lawful activity into nuisance. So here also intention is there, because you wanted to cause discomfort to somebody. So you did a lawful thing, but you wanted to do it to cause damage to somebody or injury to somebody. And malice or motive may result in aggravation of damages. If there are aggravated damages, if the damages are relevant here, the court will look at whether there was malice to decide on the quantum of damages. This was with respect to introduction to the law of torts. We will now move on to the general defenses in torts in the next lecture.